Now I've gone to the CARA regulations, Regulation 5.3 of the adoption regulations, and I've said that Regulation 5.3 of the adoption regulations exceeds the scope of the JJ Act. These regulations only permit persons to adopt in an individual capacity and not jointly as an unmarried couple. Regulation 5.2 states that every person, irrespective of whether they are married or unmarried, will be able to be prospective adoptive parents. The subsequent criteria in Clause A, that is the requirement for the consent of both spouses if they are married, does not exclude an unmarried couple from adopting. It only states that if a couple is married, then the consent of both the parties shall be secured. However, Regulation 5.3 in express terms excludes unmarried couples from adopting by prescribing the condition that the couple must have been in 2 years of a stable marital relationship. As observed in the previous paragraph, the JJ Act the Juvenile Justice Act does not preclude unmarried couples from adopting. Though Section 57 of the Act grants CARA the power to prescribe additional criteria, the criteria must not exceed the scope of the legislative policy. Neither the general principles guiding the JJ Act nor Section 57 in particular preclude unmarried couples from adopting a child. In fact, all the other criteria ensure the child's best interest. The Union of India has not proved that precluding unmarried couples from adopting a child, even though the same people are eligible to adopt in their individual capacity, is in the child's best interest. Thus, CARA has exceeded its authority by prescribing an additional condition by way of Regulation 5.3, which is contrary to the tenor of the Juvenile Justice Act and Section 57 in particular. The adoption regulations use marriage as a yardstick to classify couples. There is an intelligible differentia in using marriage as an indicator to classify couples in the sense that married couples can easily be distinguished from unmarried couples. However, the differentia does not have a rational nexus with the object sought to be achieved by the CARA regulations, which is to ensure that the best interest of the child is protected. Placing a child in a stable family is undoubtedly in pursuance of a child's interest. However, the respondents have not placed any data on the record to support their claim that only married relationships can provide stability. It is true that separating from a married partner is a cumbersome process when compared to separating from a partner with whom a person is in a live-in relationship. This is because separation from a married partner is regulated by the law, while live-in relationships are unregulated by law, other than for the limited purposes of domestic violence. For instance, the law deters a person from securing a divorce immediately by prescribing conditions such as a 6-month waiting period after a petition for divorce by mutual consent is filed. Merely because a marriage is regulated by the law, it cannot be assumed that marriage alone or that every marriage accords stability to a relationship. Similarly, it cannot also be inferred that the couples who are not in a married relationships are not serious about the relationship. The stability of the household depends on various factors, such as the effort and involvement of the partners in establishing and running a household, creating a safe space at home, creating a healthy work-life balance, and a household where mental, physical, and emotional violence is not inflicted on one another. There is no single form of a stable household. There is no material on the record to prove the claim that only a married heterosexual couple would be able to provide stability to the child. In fact, this court has already recognized the pluralistic values of our Constitution, which guarantee a right to different forms of association. Regulation 5.3, though facially neutral, indirectly discriminates against atypical unions, such as the relationship between non-heterosexual partners, which have not been recognized by the state. Queer marriages have not been recognized by the state, and queer persons in atypical unions cannot yet enter into a marriage which is recognized by the state. Though the additional criteria prescribed by the adoption regulations would also affect a heterosexual person's eligibility to adopt a child, it would disproportionately affect non-heterosexual couples. This is because the state has not conferred legal recognition to unions between queer persons in the form of marriage. Consequently, an unmarried heterosexual couple who wishes to adopt a child has the adoption of marrying to meet the eligibility criteria for adoption. However, this option is not available to queer couples. When Regulation 5.3 is understood in the light of this position, a queer person who is in a relationship can only adopt in an individual capacity. This exclusion has the effect of reinforcing the disadvantage already faced by the queer community. The law cannot make an assumption about good and bad parenting based on the sexuality of individuals. Such an assumption perpetuates a stereotype based on sexuality that only heterosexuals are good parents and all other parents are bad parents, which is prohibited by Article 15. This assumption is not different from the assumption that individuals of a certain class or caste or religion are better parents. In view of the above observations, the adoption regulation is violative of Article 15 for discriminating against the queer community. According to the adoption regulations, unmarried couples cannot jointly adopt a child. Though the additional criteria prescribed by the CARA circular would also affect a heterosexual person's eligibility to adopt a child, it would disproportionately affect non-heterosexual couples. This is because the state has not conferred legal recognition to the unions between queer persons in the form of marriage. Consequently, an unmarried heterosexual couple who wishes to adopt a child has the option of marrying to meet the eligibility criteria for adoption. However, this is not an option for queer couples. When the CARA circular is read in the light of this legal position, a person of the queer community would be forced to choose between their wish to be an adoptive parent and their desire to enter into a partnership with a person they feel love and affinity with. This exclusion has the effect of reinforcing the disadvantage already faced by the queer community. For these reasons and the reasons recorded in section D so and so, the CARA circular is violative of Article 15 of the Constitution. In view of the deeming fiction created by section 12 of the Hindu Adoptions and Maintenance Act 1956 and section 63 of the JJ Act, an adopted child is a legitimate child of the adopting couple. The manner of determination of legitimacy prescribed by section 112 of the Indian Evidence Act shall not apply in view of the deeming fiction created by section 12 of the Hindu Adoptions and Maintenance Act and section 63 of the JJ Act. Thus, all the benefits which are available under the law to a legitimate child who has been validly adopted of a married couple will equally be available to the legitimate child of an unmarried couple. For example, section 20 of the Hindu Adoptions Act, which provides that a Hindu is to maintain their children, does not make any distinction between a legitimate child of a married and unmarried couple. Similarly, succession law in India does not differentiate between the child of a married and unmarried couple if the child has been adopted by following the due process of law. Further, the breakdown of the relationship of an unmarried couple will not lead to a change in applicable law because the child will continue to be a legitimate child even after the breakdown of the relationship. It is therefore unclear what the disastrous consequences referred to are. My learned brother has also failed to address whether Regulation 5.3 is discriminatory for distinguishing between married and unmarried couples for the purpose of adoption and for the disproportionate impact that it has on the members of the queer community, while simultaneously holding that the state cannot on any account make regulations that are facially or indirectly discriminatory on the ground of sexual orientation. Now I'll pronounce my directions. The first part of my directions are directions to obviate discrimination. Counsel for the petitioners and some counsel for the respondents advanced extensive submissions on the various forms of violence and discrimination that society and the state machinery inflict upon the queer community, and especially queer couples. This has been discussed in detail in the prefatory part of the judgment. Counsel sought directions to obviate such violence and discrimination. Now my directions. A. The union government, state governments, and governments of union territories are directed to 1. Ensure that the queer community is not discriminated against because of their gender identity or sexual orientation. 2. Ensure that there is no discrimination in access to goods and services to the queer community which are available to the public. 3. Take steps to sensitize the public about queer identity, including that it is natural and not a mental disorder. 4. Establish hotline numbers that the queer community can contact when they face harassment and violence in any form. 5. Establish and publicize the availability of safe houses or garima grahs in all districts to provide shelter to members of the queer community who are facing violence or discrimination. 6. Ensure that treatments offered by doctors or other persons which aim to change gender identity or sexual orientation are seized with immediate effect. 7. Ensure that intersex children are not forced to undergo operations with regard only to their sex, especially at an age when they are unable to fully comprehend and consent to such operations. 8. Recognize the self-identified gender of all persons, including transgender persons, hijras, and others, with socio-cultural identities in India as male, female, or third gender. No person shall be forced to undergo hormonal therapy or sterilization or any other medical procedure either as a condition or prerequisite to grant legal recognition to their gender identity or otherwise. B. The appropriate government and the Mental Health Care Act must formulate modules covering the mental health of queer persons in their programs under Section 29(1). Programs to reduce suicides and attempted suicides envisaged by Section 29(2) must include provisions which tackle queer identity. C. The following directions are issued to the police machinery. 1. There shall be no harassment of queer couples by summoning them to the police station or visiting their places of residence solely to interrogate them about their gender identity or sexual orientation. 2. They shall not force queer persons to return to their natal families if they do not wish to return to them. 3. When a police complaint is filed by queer persons alleging that their family is restraining their freedom of movement, they shall, on verifying the genuineness of the complaint, ensure that their freedom is not curtailed. 4. When a police complaint is filed apprehending violence from the family for the reason that the complainant is queer or is in a queer relationship, they shall, on verifying the genuineness of the complaint, ensure due protection. And 5. Before registering an FIR against a queer couple or one of the parties in a queer relationship, where the FIR is sought to be registered in relation to their relationship, they shall conduct a preliminary inquiry in terms of Lalita Kumari versus Government of UP to ensure that the complaint discloses a cognizable offense. The police must first determine if the person is an adult. If the person is an adult and is in a consensual relationship with another person of the same or different gender, or has left their natal home of their own volition, the police shall close the complaint after recording a statement to this effect. Conclusions and orders of enforcement. In view of the discussion above, the following are the conclusions. This court this court is vested with the authority to hear this case. Under Article 32, this court has the power to issue directions, orders, or writs for the enforcement of the rights in Part 3. B. Queerness is a natural phenomenon known to India since ancient times. It is not urban or elite. C. There is no universal conception of the institution of marriage, nor is it static. Under Articles 245 and 246 of the Constitution, read with entry 5 of List 3 to the 7th Schedule, it lies within the domain of Parliament and the state legislatures to enact laws recognizing and regulating queer marriage. D. Marriage has attained significance as a legal institution largely because of regulation by the state. By recognizing a relationship in the form of marriage, the state grants material benefits exclusive to marriage. E. The state has an interest in regulating the intimate zone to democratize personal relationships. F. The issue of whether the Constitution recognized the right to marry did not arise before this court in Justice K.S. Puttaswamy, 9 judges, Shafin Jahan, and Shakti Vahini. G. The Constitution does not expressly recognize a fundamental right to marry. An institution cannot be elevated to the realm of a fundamental right based on the content accorded to it by law. However, several facets of the marital relationship are reflections of constitutional values, including the right to human dignity and the right to life and personal liberty. H. This court cannot either strike down the constitutional validity of the Special Marriage Act or read words into the Special Marriage Act because of its institutional limitations. This court cannot read words into the provisions of the SMA and provisions of other laws, allied laws, such as the Indian Succession Act and the Hindu Succession Act, because that would amount to judicial legislation. The court, in the exercise of the power of judicial review, must steer clear of matters, particularly those impinging on policy, which fall within the legislative domain. I. The freedom of all persons, including queer couples, to enter into a union is protected by Part 3 of the Constitution. The failure of the state to recognize the bouquet of entitlements which flow from a union would result in a disparate impact on queer couples who cannot marry under the current legal regime. J. In Article 15.1, the word sex must be read to include sexual orientation, not only because of the causal relationship between homophobia and sexism, but also because the word sex is used as a marker of identity, which cannot be read independent of the social and historical context. K. The right to enter into a union cannot be restricted based on sexual orientation. Such a restriction will be violative of Article 15. Thus, this freedom is available to all persons, regardless of gender identity or sexual orientation. L. The decisions in Navtej and Justice K.S. Puttaswamy, 9 judges, recognize the right of queer couples to exercise the choice to enter into a union. This relationship is protected from external threat. Discrimination on the basis of sexual orientation will violate Article 15. M. Transgender persons in heterosexual relationships have the right to marry under existing law, including personal laws which regulate marriage. N. Intersex persons who identify as either male or female have the right to marry under existing law, including personal laws which regulate marriage. O. The state must enable the LGBTQ community to exercise its rights under the Constitution. Queer persons have the right to freedom from coercion from their natal families, agencies of the states, including the police and other persons. P. Unmarried couples, including queer couples, can jointly adopt a child. Regulation 5.3 of the adoption regulations is ultra vires the Juvenile Justice Act, Articles 14 and 15. Regulation 5(3) is read down to exclude the word marital. The reference to a couple in Regulation 5 includes both married and unmarried couples as well as queer couples. The principle in Regulation 5(2)(a) that the consent of spouses in a marriage must be obtained if they wish to adopt a child together is equally applicable to unmarried couples who seek to jointly adopt a child. However, while framing regulations, the state may impose conditions which will subserve the best interest and welfare of the child in terms of the exposition in this judgment. Q. In view of the interpretation of Regulation 5(3) of the adoption regulations, the issue of whether the CARA circular disproportionately impacts the queer community no longer arises. R. The union government, state governments, and governments of union territories shall not discriminate against the freedom of queer persons to enter into union with benefits under law. And S. We record the assurance of the Solicitor General that the union government will constitute a committee chaired by the Cabinet Secretary for the purpose of defining and elucidating the scope of the entitlements of queer couples who are in unions. The committee shall include experts with domain knowledge and experience in dealing with the social, psychological, and emotional needs of persons belonging to the queer community, as well as members of the queer community. The committee shall, before finalizing its decisions, conduct wide stakeholder consultation amongst persons belonging to the queer community, including persons belonging to marginalized groups, and with the governments of the states and union territories. The committee shall, in terms of the exposition in this judgment, consider the following. 1. Enabling partners in a queer relationship, A, to be treated as a part of the same family for the purposes of a ration card, and B, to have the facility of a joint bank account with the option to name the partner as a nominee in case of death. 2. In terms of the decision in Common Cause versus Union of India, as modified by Common Cause versus Union of India 2, medical practitioners have a duty to consult family or next of kin or next friend in the event of patients who are terminally ill and have not executed an advance directive. Parties in a union may be considered family for this purpose. 3. Jail visitation rights and the right to access the body of the deceased partner and arrange the last rites. And 4. Legal consequences such as succession rights, maintenance, financial benefits such as under the Income Tax Act 1961, rights flowing from employment such as gratuity and family pension and insurance. The report of the committee chaired by the Cabinet Secretary shall be implemented at the administrative level by the Union government and the governments of the states and the Union territories.